Welcome to the lesson on Corporate Environmental Responsibility, CER, and the legal framework for environmental protection in the UK. As usual, the learning materials for this topic can be found in the description, below the video, in order of appearance. Let us begin by recalling that corporate environmental responsibility, CER, is now recognized as an essential and non-controversial component of corporate social responsibility, CSR. In contemporary corporate governance, considerations for the planet, from sustainability to carbon reduction, are seen as both a moral obligation and a business imperative. Today, most major corporations publicly anchor their CSR platforms in environmental sustainability, emphasizing sustainable sourcing, waste reduction, and net zero commitments. However, this was not always the case. As suggested by Carrie Julia Bradshaw, when the CSR debate began almost a century ago, it revolved primarily around the philosophical and legal question of what or whom the corporation is for. As E. Merrick Dodd and Berle Jr. discuss, writing separately, the early dialogue focused on whether corporations should be managed solely in the interest of shareholders or whether they owed duties to a broader set of stakeholders, employees, communities, and the environment. By the latter half of the 20th century, CSR advocates began to emphasize the so-called business case for responsibility, the idea that ethical and environmentally sustainable behavior could enhance long-term profitability. Johan Classen and Johan Dahlstrom suggest that this argument gained traction with the rise of consumer activism. Companies perceived as environmentally harmful faced boycotts, while those seen as responsible benefited from customer loyalty. Yet, it remains uncertain whether CSR and CER systematically improve financial performance. For many corporate leaders, the key question persists: can environmental responsibility coexist with profit maximization? If sustainability initiatives are not profitable, will they survive in the long run? This tension highlights a structural conflict between economic and environmental goals. Corporations are, by design, motivated to maximize financial return, while society increasingly demands that they minimize environmental harm. Bridging this divide requires more than voluntary pledges. It requires law and policy intervention that align market incentives with environmental protection. This takes us to the need for legal intervention. Environmental harms are complex, global, and often incalculable in monetary terms. As such, leaving enforcement of CER to consumer choice or corporate goodwill is neither reliable nor consistent. True progress requires legislative integration of environmental considerations into corporate governance frameworks. This must be holistic, addressing the behavior of all stakeholders, from manufacturers to investors, rather than piecemeal regulation. As Carrie Julia Bradshaw recognizes, corporations also tend to respond more readily to formal legal obligations than to public pressure. Accordingly, the strength of CER in any given jurisdiction depends largely on the breadth and enforcement of environmental law. Let us now turn to the evolution of such law in the United Kingdom by starting with the Environmental Protection Act, EPA, 1990. The EPA 1990 remains a foundational statute in the UK's environmental regime. It covers air pollution control, focusing on prevention and reduction of emissions into the environment, waste management, prohibiting unauthorized or harmful disposal of waste on land and imposing a duty of care on producers to prevent escape of pollutants, and statutory nuisances, obliging local authorities to inspect their areas and address issues such as smoke, fumes, dust, noise, and odor. The EPA laid the groundwork for a comprehensive approach to pollution and waste, later reinforced by European and domestic legislation. We should also consider the Environment Act 1995 and the creation of the Environment Agency. The Environment Act 1995 built upon the EPA by establishing the Environment Agency, the UK's principal regulator for air and water quality, waste management, and contaminated land. This institutional reform ensured a more centralized and consistent approach to environmental governance. In addition, the Environmental Permitting England and Wales Regulations 2010 consolidated previous laws governing hazardous waste, bringing the UK in line with a series of EU directives, notably the Waste Framework Directive, Landfill Directive, and Water Framework Directive. These EU instruments collectively sought to ensure that waste management activities did not endanger human health or the environment. Two EU measures were particularly influential: the Waste Electrical and Electronic Equipment Directive, 2007, promoting recycling, recovery, and reuse of electronic products, and the Restriction of Hazardous Substances Directive, 2011, which limited the use of toxic materials such as lead and cadmium in manufacturing. Together, these directives imposed obligations on manufacturers to manage products' end-of-life impacts and to finance collection and recycling programs, an approach that linked producer responsibility with environmental accountability. Following the UK's withdrawal from the EU, both the Waste Electrical and Electronic Equipment Directive and Restriction of Hazardous Substances Directive have been retained in domestic law as UK statutory instruments, now administered by the Office for Product Safety and Standards. The retained EU law, Revocation and Reform, Act 2023, however, allows for future modification or repeal, which may create regulatory uncertainty going forward. In addition, the Climate Change Act 2008 represents one of the most significant legal developments in UK environmental law. It established a legally binding framework for reducing greenhouse gas emissions and set the target of achieving net zero emissions by 2050, a goal since reaffirmed in 2019 amendments to the Act. Central to this legislation is the concept of carbon budgets, which cap the total volume of emissions permitted over 5-year periods. When emissions rise in one sector, they must be offset by equivalent reductions elsewhere. This mechanism ensures a cross-sectoral, economy-wide approach to emission control. The Climate Change Committee, an independent statutory body, monitors progress and advises the government, making the UK one of the first countries to institutionalise climate accountability within its legal system. A further example of law-driven CER is the Energy Savings Opportunity Scheme, ESOS, created under the ESOS Regulations 2014. Administered by the Environment Agency, the scheme requires large private sector entities, defined as those employing over 250 staff or with annual turnover above £42.5 million, to conduct independent energy audits. The audits assess energy use across buildings, industrial processes, and transport, producing recommendations for efficiency improvements. While the recommendations are not legally binding, ESOS has been credited with delivering substantial economic and environmental benefits, estimated at £1.6 billion in net savings to the UK economy and significantly improving corporate energy performance. Let us now consider some recent and emerging legal developments. Beyond the frameworks discussed above, several new or evolving legal instruments have further shaped CER in the UK. The Environment Act 2021, the first major post-Brexit environmental statute, established legally binding environmental targets, created the Office for Environmental Protection, and introduced requirements for biodiversity net gain and waste minimization. The Plastic Packaging Tax, 2022, incentivizes use of recycled materials by taxing manufacturers of plastic packaging with less than 30% recycled content. The Sustainable Disclosure Requirements and Task Force on Climate-Related Financial Disclosures, now disbanded, compel large companies and financial institutions to report on climate risks and sustainability impacts, linking CER with corporate transparency and investor accountability. Note that the monitoring work of the task force was taken over by the IFRS Foundation. In conclusion, while corporate environmental responsibility began as a moral and voluntary dimension of CSR, it has increasingly become a matter of legal obligation. The UK's environmental regime, from the EPA 1990 to the Climate Change Act 2008, and more recently the Environment Act 2021, reflects a gradual but decisive shift toward embedding environmental stewardship within corporate governance. Yet challenges remain. The effectiveness of CER depends on consistent enforcement, coherent regulation, and a continued effort to reconcile economic efficiency with ecological responsibility. As the global climate crisis deepens, the role of law in transforming corporate behavior, from compliance to genuine sustainability, has never been more critical. Thank you for your interest in this topic. We hope this lesson was helpful to you and are looking forward to seeing you again soon.